அனைவருக்கும் வணக்கம். அதாவது என்ன அப்படின்னு பார்த்தீங்கன்னா, நம்ம ஒவ்வொரு நாளும் நம்மளை வந்து பட்டு தீட்டிக் கொண்டே தான் இருக்கோம். ஒரு சிறந்தவர்களாக திகழ்வதற்கு அப்படிதானே இல்லையா? ஸோ அந்த வகையில என்ன அப்படின்னா, இப்போ சிவில் ஜட்ஜ் கால்ஃபர் பண்ணியிருக்காங்க. ஸோ அதுக்கு பயங்கரமா நம்ம வந்து எஃபோர்ட் போட்டு டெடிகேஷனா ஒர்க் பண்ணிட்டே இருக்கோம். படிச்சுட்டே இருக்கோம் கன்டினியூவா. அது இந்த எக்ஸாம்ல ரொம்ப ஒரு வைட்டல் ரோல் அப்படின்னு பார்த்தீங்கன்னா, ஐபிசிக்கு உண்டு. ஆனா வந்து அந்த ஐபிசி எப்படி படிக்கிறது? எந்த மாதிரி எடுக்கிறது? நம்மளால படிச்சு முடிச்சிடலாமா? சிவில் ஜட்ஜுக்கு போர்ஷன் கவர் பண்ணிடலாமா? இப்படின்ற டவுட் வந்து நமக்குள்ள இருக்கும். என்னதான் நம்ம படிச்சாலும். பட் அந்த டவுட் இனிமே வேண்டவே வேண்டாம். ஏன் அப்படின்னு பார்த்தீங்கன்னா, இந்த வீடியோ பார்த்தாலே உங்களோட டவுட் எல்லாமே கிறிஸ்டலாகவே கிளாரிஃபை ஆகிடும். ப்ரீவியஸ் வீடியோஸ் யாரும் ஐபிசியில் பார்க்கல அப்படின்னா கீழே டிஸ்கிரிப்ஷனில் லிங்க் கொடுக்குறோம். அதை மறக்காமல் பார்த்துட்டு இதை பார்த்தீங்கன்னா கண்டிப்பாக யூ வில் கெட் அ குட் கிளாரிட்டி அப்படின்னே வந்து சொல்லலாம். ஸோ நம்ம கோவில்பட்டி ஜுடிஷியல் மேஜிஸ்ட்ரேட் மிஸ்டர் M.PETER சார் வந்து என்னென்னா இந்த செஷனில் பார்த்தீங்க அப்படின்னா ரொம்ப ஒரு கிளியர் கிறிஸ்டலாக என்ன பண்ணியிருப்பாங்க அப்படின்னு பார்த்தீங்கன்னு வச்சுக்கோங்க. எதெல்லாம் இம்பார்ட்டன்ட் செக்ஷன்ஸ், சாப்டர்ஸ், அப்புறம் வந்துட்டு ப்ரிசிடென்ட்ஸ், முக்கியமான ப்ரிசிடென்ட்ஸ் எல்லாமே ரிலேட் பண்ணி சூப்பராக எக்ஸ்பிளைன் பண்ணியிருப்பாங்க. ஸோ அதை வந்து நீங்கள் கண்டிப்பாக வந்து இந்த வீடியோஸ் எல்லாமே வந்து ஃபுல்லாக பாருங்கள். பார்த்துட்டு உங்களுக்கு எது டவுட் எதுவும் இருந்துச்சுன்னா கமெண்டில் போடுங்க. வி வில் ரெஸ்பாண்ட் யூ. ஸோ வாங்க வீடியோக்குள்ளே போகலாம்.
Once again, I thank you so much for giving me this opportunity to take classes on IPC. And today we are going to see or discuss criminal force and assault, wrongful restraint and wrongful confinement, kidnapping and abduction, and sexual offenses. Particularly section 339 to 376, except the unnatural offense which was struck down by the Honorable Apex Court. These are the sections that we are going to discuss today. And I make it clear at the outset that my purpose is to give some understanding of each section. I am not going in detail of or minute detail of each section, the nuances of it, but how section is structured and the application of it and what is the background. And if I give that, that is sufficient for you, because as aspirants for these exams, you are preparing well. So this is my purpose. Now with that idea in my mind, I have prepared and I'm presenting the talks accordingly, even in the past and today and even in the future if I'm given chance to. So today we are going to see, as I said earlier, criminal force, assault, wrongful restraint, wrongful confinement, kidnapping and abduction, and sexual offenses, because it comes under the broad category called the offenses against body. Already we have seen in the last class with regard to homicide and the offenses against body, particularly the grievous hurt and all those things we have seen in the last class. Today we are going to see these things, as I said earlier. The first one is section 349, force. The understanding of the term force is necessary to understand criminal force as well as the term called assault. So in section 349, what is defined is the term called force. It does not constitute any offense at all. Under section 349, if you go through, what is given there is only the definition of the term force, not the essential ingredients or what constitutes offense under the term called force. And the term force has been defined in this section in a meticulous way. What is force? If you read comprehensively, totally the section, it is now defined in a meticulous way. The first para can be summarized as the exertion of energy or producing a movement or change in the external world. By force, you can mean that by producing an energy, you are moving something, you are producing something, or a change is made, or a movement is caused. That is the summary of the first part of the section 349. The second para deals with some circumstances wherein some other body is interposed. It comes in interplay. It may, something comes in and it plays a role. It deals with some circumstances wherein some body is interposed between the person using the force and the person on whom force is used. So there is a person who uses a force, and there is a person against whom a force is used. So there is something comes in, and that plays a role of interposing. So by that, some circumstances wherein we can come to know that these are forces. And what we have to keep it in mind is, particularly, force is used against another person, not against a inanimate object, on things. So here force is to be meant, a force is used against another person, by a person against another person, not on inanimate things. So this is what we try to know under section 349 of force. It's only the definition of force. The first part is what is force, and second part is some circumstances wherein the force is used or force is explained. Now we go to section 350, criminal force. So by mere force, it does not constitute an offense. When it is done with the intention, when it is done with knowledge of causing some injury or fear or apprehension that he is going to be affected, then it becomes a criminal force. What are the essential ingredients of force? So there are four ingredients which go and constitute the criminal force, the offense of criminal force. The first one is there must be use of force as defined in section 349. So there must be a force first. Then that force should be used intentionally, very deliberately, wantonly. And third, used against another person, as I said. So here, force is meant to be used by a person against another person. The fourth one is should have been used without the consent of the person against whom the force is used. So these are the four ingredients. First, there must be a use of force. Second, it must be used intentionally. Then it must be used against another person. Then it must be used against the consent or the will of another person. So what is material in this section under criminal force is that it should have been used in pursuit of committing an offense. As I said, mere force is not an offense under this section, but it should be committed in pursuit of committing an offense. Second, there must be an intention to cause or knowingly that it is likely to cause injury, fear, or annoyance to others. So these are things which have to be kept in mind under this section. So now, without consent, what is to be kept in, what we have to, what we are understand, rather, what kind of understanding that we have by the term called consent is the word consent. Under section 90 of IPC, we have a consent. There it's, it's a question of exception because it comes, as I said, every section has to be understood subject to the exceptions given under chapter 4 of IPC. So here, we have to take into consideration what is given in section 90 of IPC. And we know the difference between doing an act without one's consent and against his will. There is a vast difference between committing an offense against one's will and without the consent of the person. So now we go to section 351 called assault. Assault, what we mean by assault? What are the essential ingredients of assault? Section 351. The accused should make a gesture or preparation to use criminal force. That's what the first ingredient. Assault, when the accused is committing assault, he must make a gesture or preparation to use criminal force. Secondly, that should be done in the presence of the person in respect of whom it is committed. So it should be done in the presence of a person. And third, there should be intention or knowledge on the part of the accused. So first I said there should be a gesture or preparation to use criminal force against another person. Then it should be done in the presence of another person against whom the assault is committed. The third is there should be an intention or knowledge on the part of the accused. That's the third ingredient under assault. The fourth one is that gesture or preparation actually has caused apprehension in the mind of the victim. So the assault, when you try to commit the offense assault, it should create an apprehension on the part of the victim, that it should create fear or annoyance or some other feeling. So these are the things, these are the four ingredients under the term called assault. So what do you mean by gesture or preparation? As I said, the gesture or preparation must be done with intention or knowledge that it's likely to cause annoyance or fear or apprehension, what it might be. So if it is done with that, then it comes under gesture or preparation, certainly that goes to constitute the offense called assault. The second one is mere words. When you utter something, the mere word does not amount to assault, but they should be used in aid of. So when you are committing an assault, and when you are doing some, when you are uttering something, when you are stating something, per se does not constitute an offense, but those words must be said in aid of. It must be assisting for the commission of the offense. Then it is called gesture or preparation, which comes under called the term assault. So now I'm going to give some illustrations or some circumstances wherein the assault is to be better situated or understood. The first one is when you take a gun and pointing at somebody. That gun may be loaded or unloaded, but the act of pointing a gun against another person creates an apprehension or causes an apprehension in the mind of the another person against whom it is done, against whom it is made. You may have a fear, you may have an annoyance, and some other things also you might have been caused. So this is one example for assault. The second one is when you take a sword and when you raise it against another person, that is also called assault. Or even simple example, lifting a lathi or a stick, or throwing a brick at another person, or advancing with a threatening attitude to stick blows. So you are going and threatening a person that I will do, and I'm going to attack with blow, I'm going to give a blow with the lathis or stick. So these are few examples. No, it's not exhaustive, but few examples that I have given for better understanding of called assault. Section 352, as we know, it's only the punishment prescribed for assault or criminal force otherwise than on provocation. So here, section 352 is a section deals with the punishment for assault or criminal force otherwise than on provocation. So now, as usual, we have to go. What is provocation or what is sudden or grave provocation? It's just exact verbatim of section 300 subclass 1 of IPC. Under section murder, we have some 1 to 4 classes. There we have given kind of in one sudden provocation some examples we had. That same is applied to this. The first one is you cannot seek for provocation which is voluntarily made by you or caused by you. You cannot take an exception for that. The second provocation is done by a person in a status of public servant. The third is when the provocation is caused in obedience to law. These are things already we have seen it. So these things cannot be sought for by the accused as an excuse that he can be exempted from, or his act can be absolved from the punishment under section 352 by causing for committing assault or criminal force. Next, section 358, assault or criminal force on grave provocation. So as I said, the same thing is, it is subject to the same explanation given under section 352 CRPC. So here also assault or criminal force on grave provocation. The same thing, all these exceptions will be applied or it is subjected to the exceptions given under section 352. Now we go to section 353. I think I'm going fast because we need to cover within an hour some sections. So I am well aware that I am going a little fast. and I try to reduce the speed, but it's my attempt to cover at least some sections because you are already preparing, and it's my intention to just help you to remember all those things, nothing more, because we are all I mean, more than me, you are in touch with all those things. So just we are going, and I'm trying to help you to remember all those things, all those sections which you already in preparation of. Section 353, assault or criminal force to deter public servants from discharge of his duty. So now, assault or criminal force is caused against a public servant who is discharging his duty in the state of a public servant. So now, normally, a kind of protection is given to a public servant. Normally, because he has to discharge his official duty. So under this section, a kind of protection is offered or given to a public servant. This protection is given only to an officer engaged compulsorily in discharge of his official duty. So while an assault or criminal force is caused against the public person, what is expected of? He must be compulsorily in engagement of discharge of his official duty. He may be a public servant, but while criminal force or assault is caused against that man, he might not have been under the discharge of duty at that particular time. So while the alleged commission of offense is done against that person, he must be under compulsory discharge of official duty. That's what we should have the understanding under section 353. What are the ingredients under section 353? First, the victim must be a public servant. As I said, he must be a public servant. Then, when assault, he must have been acting in execution of his duty. He must be engaged in execution of his official duty. And assault was intended to deter him from discharging his duty. So, the intention was to deter him, to prevent him from exercising his or discharging his public duty. And it was in consequence of exercising such knowledge and such official duty or lawful duty. So these are the ingredients that we should keep it in mind under section 353. So it is to be deterring or preventing a public servant, the alleged criminal force or assault is used. Then certainly we can invoke the offense under section 353 of IPC. Now we go to section 354. Assault or criminal force to women with the intent to outrage her modesty. So already force or criminal force or assault is committed. And there, what is to be paramount is with the intent to outrage her modesty, a woman's modesty. Now, under this section, what is to be proved? First, use of assault or criminal force. So that is first thing. So to prove under this section, what we have to do is first is use of assault or criminal force. The second one is the same criminal force or assault is committed with the intent to outrage one's modesty, particularly the modesty of a woman. But under IPC, nowhere it is defined what is modesty, outraging modesty. But through the decisions of both Honorable High Courts and the Apex Court, we have some little understanding about modesty under IPC. The essence of woman's modesty is her sex, not sexuality, is her sex, because we are male, they are female. So the modesty is just the sex. The modesty of an adult female is lit lot on her body. So if something is done against her body, the sex, then certainly it comes under outraging modesty. That woman may be young or old, intelligent or aware or sleeping. The woman possesses a modesty capable of being outraged. So it's a question of not insulting the sex, the body, whoever may be young or old. If we are doing or if we are committing against the outraging the modesty, the sex of a woman or a body of a woman, then it comes under the term called modesty. And what Oxford Dictionary says is with regard to outraging modesty, the meaning of outraging modesty given in Oxford Dictionary as womanly propriety, the womanly conduct or behavior expected of a woman. Womanly propriety of behavior, scrupulous chastity of thought, speech, and conduct, reserve or sense of shame proceeding from instinctive aversion to impure or coarse suggestions. So nothing should be done, in such a way that a woman have a kind of aversion or coarse suggestions. Then certainly it is outraging the modesty as per the meaning given or defined or given in the Oxford Dictionary. Now we go to section 355. Section 355. Assault or criminal force with the intent to dishonor a person otherwise than on grave provocation. The same thing again. It is subject to grave provocation. Given under section 352 as well as section 300 plus 1 of IPC. But it is done with the intent to dishonor a person. So intent to dishonor a person is the essence or crux of this section. So intention to dishonor a person is the very life of this section. Intention to dishonor must exist while criminal force or assault is committed. So you need to prove there existed intention while the offense is committed under section 355. What is paramount, what is more important is, what is crucial is that there existed intention while committing assault or criminal force with the intent to dishonor a person. Now we go to section 356. Assault or criminal force in attempt to commit theft of property or carried off a person. So it is mainly against pickpocketing. So this section 356 comes, rather it is given against, particularly against pickpocketing. And it becomes inapplicable the moment theft is committed. So here we must have little understanding. Where section 356 can be invoked is the moment you have taken away from the person without his consent, then the question of theft comes into play. But before that, we can invoke the section under section 356. Assault or criminal force in an attempt to commit theft of property carried by a person. So a person is carrying something, we want to take it away from him or steal from him. Then when we make an attempt, then it is called 356. Once you take away the property from him, then there is no question of invoking this section under section 356, but rather it comes under section 379. Now we go to section 357. Assault or criminal force in attempt to wrongfully to confine a person. This is very simple to understand. So criminal force or assault is used to wrongfully confine a person. Now we go to again section 354 A, B, C, D. So here, indecent assault on minor. So the section 354 A is based on it is inserted or introduced to IPC after 42nd Law Commission report. So section 354 A to D was introduced to IPC after 42nd Law Commission report. Section 354 A is a sexual harassment and punishment for sexual harassment. And it was particularly inserted through Criminal Law Amendment Act. So 354 A, as I said, 354 A to D was inserted to IPC through Criminal Law Amendment Act 2013, and which came into force from 3 to 2013. Maybe because why I'm stressing is maybe for one word or for a preliminary exam it may be useful. So that 354 to AD was introduced through Criminal Law Amendment Act 2013, which came into effect from 3 to 2013. And this provision had origin where how it came into to be originated in IPC is after the judgment by the Apex Court in Visaga versus State of Rajasthan in 2010 or 11. So after this judgment, this thought came into being inserted into IPC, and particularly after it was brought into IPC after the famous Nirbhaya's case. Now, what we are what we have to keep in mind, or the understanding that we to have a better understanding of this section, we need to have understanding of the term called sexual harassment. So, what are the ingredients of sexual harassment? One is either physical contact or advances involving unwelcome or explicit sexual overtures. Again, I read, the first ingredient which go and constitute sexual harassment is either physical contact or advances involving unwelcome and explicit sexual overtures. The second one is a demand. The mere demand or request for sexual favors is also sexual harassment. The third, making sexually colored remarks. The fourth one is forcibly showing pornography. So these four will define what is sexual harassment. Each one can be taken separately and can constitute an offense called sexual harassment. The first one is, it may be a physical contact or making an advance, unwelcoming overtures or explicit sexual overtures. That's also sexual harassment. Or when you make a demand or a request for sexual favors, that is also sexual harassment. And when you are making intentionally that sexually colored remarks, that is also harassment, sexual harassment. And fourth one is when you are forcibly showing pornography pictures to the woman, that's also called sexual harassment. And unwelcome, literally if you take it, what is unwelcome or explicit sexual overtures is, unwelcome is that's not voluntarily take or asked by a person, a woman, then that becomes a concern. So that's what we see. So without consent of a person or unwelcome by a person, then it can we can call it as a sexual harassment. Now, based on this, there are amendments also made in the CRPC as well as IPC also, the Indian Evidence Act. In CRPC, there are some amendments made with regard to this section. The first one is section 154 of CRPC. If you go and read section 154 of CRPC, there a provider was annexed to that section, because when there are offenses, particularly of this sexual harassment and rape, 376 A to D. So with regard to these offenses, while registering FIR, what is to be done? So that amendment was brought in CRPC after this one. And section 161 of CRPC, examination of witnesses by police. When a woman becomes victim of this sexual harassment or rape, while in a recording statement under section 161 by the witnesses, what a police or investigating officer has to do, that amendment also was brought in after this. And section 164 of CRPC, recording of confession and statement. And section 164A, medical examination of the victim of rape. If you go to that section 164 of 164A of CRPC, then the victim of rape must be immediately should be taken to a registered medical practitioner for examination. So these are the amendments were brought in to CRPC after this amendment, which was brought in the IPC. Now we go to section 354B, assault or criminal force with the intention of disrobing or compelling a woman to be naked. These are the three ingredients under section 354B. So here there is an assault, there is a criminal force, but ultimately there must be an intention of disrobing or compelling a woman to be naked. Then the offense is committed under section 354B. Then we can certainly invoke the section under section 354B. Now we go to section 354C, voyeurism. So this section, voyeurism, was brought in because of the report by the Honorable Justice Verma committee in the aftermath of Nirbhaya's case, the voyeurism and other things. So what are the ingredients of voyeurism? Now, if a person either watches a woman or captures the image of a woman, that's first thing. Second, and of a woman watches or capture the image of a woman engaged in a private act. Third, in circumstances where the woman would usually have the expectation that she is not watched by anybody and by any other person at the behest of the perpetrator. So these are things, that we should have to understand the term voyeurism. So when a woman engaged in a private act, the perpetrator should not watch or clicks an image, or at the behest of the perpetrator, someone also comes into and does the same thing. That's the commit that thing, then it becomes voyeurism. So the image here may be a moving image, maybe a still image. And this offense can be committed by both male or female. We cannot have a misunderstanding that voyeurism can be committed by only male. It can be also committed by a woman if all the ingredients, as I said earlier, that when a woman engages herself in a private act or when she is free, that these sort of things should not be done. So if all the ingredients are made out, then it can be certainly made against even the woman under section 354C. What is important is under this section is consent. So when a person is in the lavatory, in the toilet, latrine, and somebody clicks a image, and if it is done with the consent of the person, then it's not offense, provided it should not be transmitted to other person. If at all the image not taken with the consent of the particular victim or the person, then it's not an offense. And without your consent, if it is transmitted to another person, then certainly it becomes an offense under this section. And why we say no? Because it is a right of the victim to prevent the sharing of or transmission of such image to third persons or other persons or the public. So this is we see under section 354C. Now we go to section 354D. That's called stalking. So what is stalking? It is a form of harassment comprising of repeated, persistent following with no legitimate reason. So you are following a woman with no legitimate reason or with the intention of harming so as to arouse anxiety or fear of harm in the person being followed. So you are following a woman having no legitimate reason or with the intention so as to harming herself and arouse anxiety or a kind of fear in her, then it becomes stalking. Then it may also take the form of harassing. Maybe when you are stalking somebody, that means you are making telephone calls repeatedly and persistently in order to harm that person or the victim. It may be in the form of computer communication, or it may be in the form of letter writing, or any other mode of unwanted or intimidating surveillance. So these sort of things will certainly constitute the offense under section offense of stalking. As I said, when it is a harassment. When you follow a woman without legitimate reason or with the intention of harming in order to arouse in her a kind of fear or anxiety, then it becomes a stalking. When you are making a continuous, repeated, persistent telephone calls, computer communication, or letter writing, or any other mode of, you follow any other mode of harassing somebody by trying to do all these things, by, in order to intimidate or making a kind of surveillance, then it is called stalking. So what is the purpose of this provision to be inserted into IPC is, or introduced to IPC is, it means it was done for the purpose of preventing, or rather, some proviso is given. Sorry, some proviso is given where if it is done with some, under some exceptions, then certainly it cannot be called stalking. For example, the first one is if the stalking was done for the purpose of preventing or detecting a crime. So maybe in obedience to law or in obedience to the order by the authority, then certainly it cannot be called stalking. If it is done for the purpose of detecting or preventing a crime. Second one is, if it is done under any law or meant to be complied with some conditions. If it is also done with that, then certainly it is not called stalking. The third one is, when you are stalking, it must be justified. It must come under some exceptions, as I said. It may be a justifiable act. So if you do that, then certainly you cannot be accused of stalking. This is what we understand through the term called stalking. Now we go to another chapter, chapter 39. Wrongful restraint and wrongful confinement. Section 339 and 341. What they deal with, what they state about is, wrongful restraint is defined under section 339 and punishment for wrongful restraint is given under section 341. Because the other two sections will for wrongful confinement. So what are the essential ingredients for wrongful restraint? So first one is, there must be voluntary obstruction of a person. So you must prevent or obstruct a person voluntarily. The second one is, obstruction must be such as to prevent that person from proceeding in any direction in which he has a right to proceed. So first, voluntary or obstructing, and you're obstructing that person from proceeding towards any direction, towards, in that he has a right to proceed. So these are the essential ingredients which constitute the offense called wrongful restraint. And mere verbal prohibition does not constitute wrongful restraint. So mere uttering, you should not go, you should not move, you should not proceed anyway. If you say like this, then it does not constitute any offense. The mere verbal prohibition or prevention does not constitute any offense under this section. And mere direction or demonstration, if you point out something, mere verbal or even making a gesture that you should not move like that, then certainly it does not constitute any offense. In order to constitute the offense, then there must be, here, what we have to understand is, physical force is not always necessary. You may do some other things, but what is to be kept in mind is that the person who is prevented should not have chance to proceed towards any direction in which he has a right. So this is the crux of the section on wrongful restraint. Now we go to section 340 and 342. 340 is the definition of wrongful confinement, and section 342 is the punishment prescribed for wrongful confinement. What are the essential ingredients for wrongful confinement? First, there should be a wrongful restraint of a person. So for wrongful confinement, the first ingredient is wrongful restraint of a person. The second, restraint must be to prevent that person from proceeding beyond. There, under wrongful restraint, he should not proceed in any direction. But whereas under wrongful confinement, the restraint must be to prevent that person from proceeding beyond certain area, certain circumscribing limits beyond which he or she has a right to proceed. So beyond certain area, beyond certain vicinity or place, if a person is prevented from proceeding, then it becomes wrongful confinement. The third one is, there must be a total restraint, not a partial one. So here, when you are confining a person to a particular area or a place or a particular limit, then it becomes complete. It's not a partial one. If a person has a chance of proceeding towards any kind of direction, then certainly you cannot be, you cannot invoke the section under section. You cannot invoke the offense under section 340 of IPC. So the restraint must be total one, a complete one, not a partial one. These are the three ingredients. And the difference between these two, of course, I'm going to give in detail what is the difference between what is wrongful confinement and wrongful restraint. In wrongful confinement, restraining from proceeding in any direction from certain area. Whereas in wrongful restraint, in some direction, in a rather in wrongful confinement, you cannot move beyond certain area. But yes, please raise a question. Yes. Any question? Saktivel Tripandi, Mr. Saktivel Tripandi. Am I not audible or clear?
Sir, you are audible, sir. Sorry for the interruption, sir. You please be continue, sir.
Yes. So I will give later on the difference between what is wrongful restraint and wrongful confinement. Now, just I'm going to read the title of each section, because it is not so important, because by reading the title itself, you can understand what it conveys. Section 343, wrongful confinement for 3 or more days. Because just if you are confining a person for more than 3 days, certain punishment is prescribed. Section 344, wrongful confinement for 10 or more days. And 345, wrongful confinement of a person for whose liberation it has been issued. Here, only the punishment is prescribed, provided there must be a writ is issued. When in spite of writ is issued and having the knowledge of it, if you are confining a person, then you can invoke the offense under section 345. Then punishment is prescribed for that offense separately. Then section 346, wrongful confinement in secret. And in secret, so that is to be given detailed explanation. But for the sake of just I'm pausing. And if you are confining a person in secret, that his whereabouts is not known to the legal custodian or lawful authorities or the natural parents or whoever it may be, then we can invoke the section under offense under section 346. Wrongful confinement in secret, that punishment only is given. And 347, wrongful confinement to extort property or constraint to illegal act. So if you are confining a person wrongfully to extort property or to make him to do illegal act, then we can invoke this section. Section 348, wrongful confinement to extort confession or compel restoration of property. So these are things why that we must have a basic understanding of what is confinement, what's wrongful restraint, and what is wrongful confinement. If you know, then these things will be easy to understand the section 343 to 348. Now we go to section kidnapping and abduction, section 359 to 374. Now, as I said before earlier, the basic difference between wrongful restraint and wrongful confinement. In wrongful restraint, you are preventing a person to move or to proceed in any direction in which he has a right. Whereas in wrongful confinement, there is a total restraint and you are confining a person to a particular area and he cannot move from that particular area. It must be a complete one, not a partial one. That is a basic difference between the wrongful restraint and wrongful confinement. Now we go to section 359 to 374, kidnapping and abduction. And last we will go to the sexual offenses. First, kidnapping and the literal meaning of the word kidnapping is child stealing. It amounts to, it is treated on par with the term called child stealing. Child stealing. That's what they keep it in British, in England. So the literal meaning of the kidnapping is child stealing. And according to Black Law Dictionary is forcible abduction or stealing or carrying away of a person from the country to another, from one country to another. So forcible abduction or stealing or carrying away of a person from one country to another, then it is called kidnapping. This is what given in Black's Law Dictionary in regard to the term called kidnapping. Kidnapping is of two kinds. Kidnapping from India and kidnapping from lawful guardianship. So under section 360, what we see is kidnapping from India. Under section 361, what we see is kidnapping from lawful guardianship. But there are circumstances in which this section will overlap each other. For example, you can kidnap a minor from India as well as equally from the lawful guardianship. So there is every possibility that these two sections will overlap each other, or sometimes they interplay with each other. Section 359 to 361 IPC, and they do not speak out any territorial jurisdiction for committing the offense. So if you go in depth reading section 359 to 361, those sections do not speak about any territorial jurisdiction for committing such offense. So it does not speak about the territorial jurisdiction. I mean, it does not speak out any area. When kidnapping complete, so the offense kidnapping becomes complete as soon as a minor girl under 16 years of age is taken out of a custody of a lawful guardianship. So kidnapping becomes complete when the moment that you take away that person from the lawful guardianship, from the lawful authority or lawful guardianship of that victim. So and it's not a continuing offense. So the moment you have taken, it becomes complete. It does not continue. So we cannot have an understanding of that whether the kidnapping will be a continuing offense. Cannot be. Section 361. The purpose of 361 is to protect the minor. If male, they should not be beyond 16 years of age. If they are female, then they should be less than 18 years of age. And here, taking away does not mean that you are using force. We cannot have this kind of understanding. So here, while you are kidnapping a person, that comes, we can have an implied meaning. But it goes just taking away a person from the lawful guardianship of the victim. And what is not relevant under this section is the consent of the minor. So again, we have to go to this exception under section 4 of the chapter 4 of the IPC. So the consent of the minor is of no material, is of no relevance, is of no consequence. And here we need to take into lawful guardianship, not the legal guardianship. Legal guardianship is a narrower understanding. It's not a broader term. But whereas lawful guardianship is a broader term. And under that, you can bring so many persons like, parents or guardians or even the teachers or the legal custodian and or persons who are appointed by the courts. So these are, they will become, they will come under the term called lawful guardianship. Whereas a legal guardianship means only the natural parents or who are come, immediate to that or nearby that. So they will become legal guardians. But here, what the section is, what the section has meant is lawful guardianship. Now we go to section 363. Section 363 just prescribes or states the punishment for kidnapping 7 years and liable to fine. So this is what the punishment prescribed under section 363 for kidnapping. Now we go to section 362, abduction. So here, abduction per se or as such does not constitute any offense. The mere abduction does not constitute any offense, provided it must be followed or accompanied by certain intent to commit another offense. So it must be followed by another thing, that it must be accompanied by the intent to commit an offense. Mere abduction cannot constitute any offense under section 362. And force or fraud is essential to make abduction not to be punished under this section. So exercise of force or fraud is important. Not to invoke the section, not to invoke under this section 362. And in IPC, nowhere is defined what is abduction. And there is no such offense called abduction under IPC. As I said, it must be accompanied by the intention to do something. Or the fraud or force is essential ingredient. under this section, as I stated above. So what are the ingredients? Now we go to, what are the ingredients which constitute the offense called, the definition of the term abduction. There's no offense called abduction. Ingredients. There must be a forceful compulsion or inducement of deceitful means. So you are exercising, or you are doing, or you are engaging deceitful means in order to defraud, to abduct that person. And the object of such compulsion or inducement must be going of a person from one place to another. Then it becomes an abduction. So when you are playing defraud, when you are playing fraud, influencing a person from one place to another with the intention of committing some other things, that becomes abduction. And abduction of an adult person per se is not punishable under the code. Here, when you are abducting an adult, that act itself or as such or per se does not constitute any offense, because they can give a consent. If they are minors, then it's a different question. But with regard to adult person, then the question of giving consent plays a major role. But in here, abduction of an adult person does not constitute any offense. To constitute offense, what we have to do, one of the essential elements is that there should be an absence of will on the part of the person abducted. So there must be an absence of will. It must be acted against the will of the person. You have influenced such a way that it is done against his will, then it becomes abduction. So what is not material, what is not necessary under this section is whether a person abducted should be a minor or a major. Such a person removed from lawful guardianship or not. These are not necessary. With regard to question of abduction, what is necessary is whether it is done against the will of a person and making him moving from one place to another, then it becomes, and it must be done with the intention, then it becomes abduction. Now we go to on section 364. What does it speak of is kidnapping or abducting in order to murder. So it's very plain. So under section 364, what we read or what we understand is you are kidnapping or abducting a person in order to murder that person. That's what we read under section 364. Now we go to section of the difference between kidnapping and abductions. First, kidnapping committed only in respect of a minor of a person of unsound mind. So I think I forgot to tell you one thing. With regard to kidnapping, it's not only a question of a minor, but it's also a person of unsound mind. So here, kidnapping is committed in respect of a minor or persons of unsound mind, lunacy, or a person who suffers mentally or mental illness, particularly mental illness, not mentally, mental illness. And abduction is maybe in respect of any other person. So with regard to abduction, as I said, what is not material is whether he was taken away from the lawful guardianship of a person or whether he is a minor. That's not a material. That's not necessary in abduction. But whereas in kidnapping, it is committed in respect of a minor or a person of unsound mind. The second difference is person kidnapped, removed out of lawful guardianship. As I said earlier, with regard to abduction, there's no question of that. That's not necessary. Now we go to the third difference between the kidnapping and abduction. Now here, while you are committing the offense of kidnapping, you are taking away or you are enticing a person to go away with the kidnapper. That means, here what kind of means is used is irrelevant. Whereas that is irrelevant in under section, that is relevant in abduction. Whereas in kidnapping, you are just taking away. You are enticing a person using some means to go away with the perpetrator, the kidnapper, the so-called kidnapper. Whereas in abduction, force or compulsion or deceitful means are used. Here, you are using means. That's important under abduction. what kind of means is used or employed. So force or compulsion or deceitful means or use is important in abduction. 4. Consent of the person is immaterial. Here, consent of the person is immaterial and in kidnapping, whereas in abduction, the consent of the person is material. And sometimes it may condone the offenses of the perpetrator. In abduction, when you are moving from one place to another, and you are exercised the fraud or deceitful means, still you go with the consent, then certainly that the alleged act can be condoned. But whereas in kidnapping, it cannot be condoned. That is culpable, that is punishable. And 5th difference is intent of the kidnapper is irrelevant. In kidnapping, the intention is irrelevant, whereas in abduction, it is paramount. It's all important factor. Intention is all important factor in abduction. And 6th one is, as I said, kidnapping is not a continuing offense. The moment you are taking away the minor or a person from the lawful guardianship then it becomes kidnapping. It's not a continuing offense, that becomes complete, that itself. Whereas abduction is a continuing offense, it goes on and on. And it is repeatedly, recurrently is committed. That's called abduction. And the 7th difference is kidnapping is outside India. That can be kidnapping from our own country to outside India. That's a territorial question. Abduction may be anywhere within or within out. So they're the same. But within you can abduct, and without India you can abduct. So these are the basic differences between the terms kidnapping and abduction. Now we go to section 363A. Kidnapping or maiming a minor. I mean, maiming means cutting. Now, kidnapping or maiming a minor for the purposes of taking. So this section was introduced in the year 1959. So this section 363A was introduced to IPC in the year 1959, and it was inserted to counter, because maybe the factor must be the question of organized begging must have increased, must have been growing. So in order to prevent and curtail that social handicap, the social that kind of unwelcome social reality to curb that, this section might have been introduced to IPC in the year 1959. So what we what we should have to understand this section is what is the meaning. What does it mean by begging? Begging means soliciting or receiving alms in the public place. So you are begging for alms in the public place, and you are entering into a private premises for the purposes of begging. You are going into another place. And 3rd, exposing or exhibiting with the object of obtaining or extorting alms. You are exhibiting, what are you are exhibiting? Any sore, wound, or injury, or deformity, or disease, whether of himself or of any other person or an animal. So you cannot exhibit your own wound, your own disease, your own deformity, or of another person, maybe your own child, or the animal, maybe that you are carrying your own pet animal. By showing or exhibiting those things, you cannot, begging alms. That also is included under the term called begging. And the 4th one is using a minor as an exhibit, as an object. So you cannot use the minor as an object in order to beg or solicit alms in the public place or in a private place. So here what we mean is, when you are begging in the public place or in a private places, by showing yourself or exhibiting yourself, your own disease, your own deformity, or your own sore or wound, yourself or your own dependent or the animal or the minor, then certainly it is begging. Then certainly you can invoke the section under section 363A of IPC. Now we go to section 364 IPC, abducting to murder. So it's very plain. Now you can have a clear understanding. When you are abducting a person to murder, then section 364 comes into play. This section will apply if a person has been abducted with the intention of murder. Whether murder has caused, that is a different question. But with the intention of causing a murder, committing a murder. If a person is abducted, then certainly we can invoke, then this section comes into play. And it is sufficient that there was abduction with the intent to murder. Whether the person is murdered, that's not required. The mere abduction with the intention to murder, then this section comes into play. That's what we see under section 364A. Now, section 364A. 364A is a kidnapping for ransom. The same thing. And first, it was inserted by the Criminal Law Amendment Act 1993. This section 364A, it was inserted by Criminal Law Amendment Act 1993. Secondly, it was amended by IPC. It was amended, followed, in the year 1955. And the purpose for introducing such section is to provide for severe punishment for abducting or kidnapping a person or keeping him continuously under detention or threatening him to cause his death or hurt or create a reasonable apprehension that he may be put to death or hurt, to compel the government or any foreign state or international or intergovernmental organization or any other person to refrain from doing any act, to pay a ransom as demanded by the kidnapper or abductor. These are all things that we have to keep in mind. The first is kidnapping for ransom. What are all things? Again, for your sake, I am reading again. For abducting or kidnapping a person or keeping him continuously, you are keeping the abducted person continuously into your custody under the detention or threatening him to cause him to death or threatening to cause hurt to that person, or by to create a reasonable apprehension that he may be put to death or hurt, to compel the government or any foreign state or international or intergovernmental organization or any other person to refrain from doing any act or to pay a ransom as demanded by the kidnapper or abductor. So this is kidnapping for ransom. So when you are taking a person and detaining him under your custody and demanding from a person or a government or a private or an organization, intergovernmental organization for ransom, then a prima facie case is made out that you can certainly invoke. Now we go to section 365. Kidnapping or abducting with intent, secretly or wrongfully, to confine a person. Again, the secretly has to be read. And it has to be read according to circumstances, each facts and circumstances of the case. So kidnapping or abducting a person with the intent, secretly or wrongfully, to confine a person. And this is what we see under section 365. Now we go to section 366. Kidnapping or abducting or inducing a woman to compel her marriage. This is very clear. So we are kidnapping or abducting a person or inducing a person in order to get married against her will. So mere abduction does not warrant section 366. Again here, as I said, the abduction does not itself constitute an offense. Mere abduction does not create an offense under section 366. Even subsequent intent or act of intercourse with a kidnapped or abducted girl cannot bring the case if such intent was absent at the time of when the accused enticed the girl. So at the time of abducting a girl, the intention was absent, and followed by that or afterwards, if there is some intercourse or some kind of close relationship with physical contact with them, then you cannot invoke this. And this section is directed against seduction under coercion or undue circumstances. Here, what should not be played is a force or coercion against the person not to marry. And when there is a concern, as I said, in abduction there may be a concern. If you are abducting an adult person, that's not an offense. It does not constitute an offense. So here it is mainly directed against that seduction under coercion or force or undue circumstances. Then we can invoke, or it comes under section 366 of IPC. What is the main ingredient for this section is abducting for forcible sexual intercourse or forcible marriage, or seducting for illicit intercourse. Now we go to section 366A. That is, the title is Procuration of Minor Girl. Section 366B, importing of a girl from foreign country. So these two sections will go together, importing and exporting a girl for some purpose. So that's called section. That's what we see under sections 366A and 366B. A states procuration of minor girl. B speaks of importing of a girl from foreign country. And these two sections were inserted into or introduced to IPC in the year 1923 in pursuance of the International Convention for Suppression of the Trafficking in Women and Children. So to prevent trafficking of women and children, and at the behest of they are rather in pursuant of the agreement, or rather treaty, the International Convention for Suppression of Trafficking in Women and Children, these two sections were introduced to IPC. And these two sections were primarily intended to punish the import or export of the girls for the purpose of prostitution. So to curb that, both importing and exporting a girl, minor girl, for prostitution, these two sections are primarily intended. Section 366A. It punishes a person who makes a girl under 18 years of age to move from one place to another with the intent to force or seduce her for illicit intercourse with other person, deals with the procuration of a minor girls from one part of India to another. So one part of India to another, within the territory of India. So here, this section 366A punishes a person or the perpetrator or the offender who makes a girl under 18 years of age to move from one place to another with intent to force or seduce her for illicit intercourse with other person who deals with the procuration of minor girls from one part of India to another. This is what we see under section 366A. B deals with import of a girl from foreign country, and they must be below the years of 21 years of age for prostitution. And normally, and when we were undergo training, in the Honorable Judicial Academy of Tamil Nadu Judicial Academy, and two respected learned counsels from West Bengal, they came and took classes, with regard to Immoral Trafficking Act, and they said it is mostly predominantly prevailing, or it is in usage, in usage in West Bengal or the border of territory of the boundary of Indian territory. There we see, but here also we see, and this kind of importing or exporting the girls for purpose of prostitution or illegal intercourse. Now, what is illicit intercourse is a sex between a man and a woman who are not husband and wife. So, beyond the marital relationship, what is happening between a man and a woman is illicit intercourse. Section 367. Kidnapping or abducting in order to subject person to grievous hurt or slavery. This is very plain. So section 367 speaks of kidnapping or abducting in order to subject a person to grievous hurt or slavery. And section 368, wrongfully concealing or keeping in confinement kidnapped or abducted person. So you are secretly detaining a person who are abducted or kidnapped. So that's what speaks of, that's what spoken under section 368 of IPC. What is important in section 368 is this section does not apply to the perpetrator of the offense of kidnapping or abducting, but only the accomplice. So here, a person is abducted or kidnapped and he is detained in one particular place. Now, the accomplice conceals the abducted person. So here it is directed against the accomplice, not the perpetrator or the offender. This is very important under section 368 of IPC. Now we go to section 369. Kidnapping or abducting child under 10 years with the intent to steal from a person. So here, in order to steal, you are kidnapping or abducting a child under 10 years, not to steal from that minor person. And here, with the intention of taking movable property, the definition of stealing, if you go and read, so you are taking away the movable property without the consent of the owner. That's what we have understanding stealing. But here also, you are abducting or kidnapping a minor below 10 years of age in order to take away a movable property from that minor person. Now we go to section 370. Buying or disposing of any person as a slave. It's not very important. But fortunately, unfortunately, rather, I happen to read a book, jurisprudence. In regard, jurisprudence. There I happen to read a passage. Professor, Latin American, professor in United States. All of a sudden in the morning, she arose from the bed, and with a confused mind, she was sitting on the bed because she happened to read a case. It happened in the 18th century in United States, where a slave was sold to another person, and the buyer happened to see a defect in that person, and because under Contract Act, if a person if the sold good is found with defects, then certainly he can file a suit. Now the buyer under contract file a suit against the original owner, the previous owner, that this object is with the defective because he is not mentally okay. He has some difficulties. He is not able to comprehend or understand. He is not with the common sense. Some list is made saying that this person is with some defect. What I'm saying is the person was treated as a slave and he was treated as an object in the 18th century in the United States. And that professor was not able to bear it because he's a black man, and that professor is also happened to be a black lady. And when we read that passage, when I read that passage, certainly we are not able to bear. So you are treated, you are treating a person with inanimate things as if that it is found with some defectives. So that's why I'm saying it's not very important. But formally, when IPC was enacted, it was qualified. Then it was with regard to slave, there's some offenses were made. Buying or disposing of any person as a slave. Just for lighted, just to have a little distraction that I cited that example. And here ingredients, there must be selling or disposal of a person who is a slave under section 370. Now, section 371, habitual dealing with slaves. So that is also not important. And section 372, selling minor for purposes of prostitution. Section 373, buying minor for purposes of prostitution. So 372, 373 deal with selling and buying of minor for the purposes of prostitution. Section 372, what is to be proved under section 372? The accused has sold or led to hire a person under the age of 18 years with the intent or knowledge that the person would be used for the purpose of prostitution. So what is first to be proved is the accused has sold or hired a person, led to be hired a person under the age of say 18 years. So sold, it must be, the person must be sold or letting to be hired under the age of 18 years with the intent or knowledge that the person would be used for the purpose of institution. That is to be proved first. Second, there must be an illicit intercourse. Illicit intercourse with any person for any unlawful or immoral purpose, or knowing that such a person will be used for such a purpose. These two things are to be proved in order to invoke the offense under section 372 IPC. Now we go to section 373 IPC. Section 373, it makes responsible a person, criminally responsible for buying, for hiring, or obtaining possession of a minor for the purpose of prostitution, illicit intercourse, immoral purpose, or unlawful purpose, as I said earlier. So now, as I said in the beginning, section 372, selling of a minor for the purpose of prostitution. Section 373, buying minor for the purposes of prostitution, illicit intercourse, immoral purpose, or unlawful purpose. Now we go to sexual offences, section 375 and section 376. 377 was already struck down by the Honorable High Court, so Honorable Apex Court, now because unnatural offences was struck down. Now only we are going to see only section 375 and 376 sexual offences. With that, we will wind up the class today. The word rape, derived from the Latin word rapio, which means to seize. So rape means only seize. From the root word, from the Latin root word, we have an understanding that's only as seize. Literal meaning is a forcible seizure. But in common parlance, in common understanding, in the common usage, what we understand by the term rape is intercourse with a woman without her consent by force or fear or fraud. So intercourse with a woman without her consent by force, fear or fraud. This is now, came into understanding as well as practice. The usage of the word, it has assumed such meaning. And now, section 375 defines what is rape, that we all know. And so many amendments were carried out, to this section in the year 1983 after, the judgment passed by the Honorable Apex Court, in the case of Tukaram versus State of Maharashtra. So after this judgment, amendments were brought into this section. And not only amendments were brought in to IPC, but the amendments also were carried out in Indian Evidence Act. In IPC, we see section 376A to D. Those sections were introduced to IPC after this particular judgment. And in Evidence Act, section 114 14A with regard to consent, the presumption of consent with regard to rape. So that amendment was also brought in after this particular judgment. Now, what are the essential ingredients under section 375 of IPC? Now, the first ingredient is there must be a sexual intercourse with a woman by a man. So first, there must be an intercourse with a woman by a man. That's the first essential ingredient. And the second ingredient, it goes, a little long list line. Such a sexual intercourse should be against her will or against her consent. So first, there must be intercourse with a woman by a man, and it should be done, or it must be committed against a woman against her will or consent, without her consent, and with consent obtained under fear of death or hurt. Then fourth, with the consent given under the misconception of fact that man is her husband. So you are giving a consent under the impression or under the misconception that you are giving consent to your husband, thinking that that consent is given to your husband. The fourth one is consent given by a reason of unsoundness of mind, or under intoxication, or under influence of any stupefying or unwholesome substance. So you are under the influence of some substance. That is E. The fourth one is consent given by reason of unsoundness of mind, intoxication, or under influence of any stupefying or unwholesome substance. So naturally, you are giving consent under the influence of some other.
Sir, excuse me, sir.
Yes, yes.
Sir, sorry for the interruption, sir.
Yes, yes, please, ma'am.
Sir, can you please explain us in bilingual, sir, please?
Okay. I will certainly. So
yes,
yes, certainly, ma'am.
Thank you, sir. Thank you.
இப்போ வந்து இதை பொறுத்தவரை என்ன சொல்றாங்க, செக்ஷன் 375 பொறுத்தவரை என்ன சொல்றா, ஃபர்ஸ்ட் வந்து ஒரு பெண்ணோட வந்து அந்த பாலியல் உறவு வந்து இருந்திருக்கணும். ஆனா அது அவங்க விருப்பத்திற்கு மாறாக அல்லது எதிராக நடந்திருக்கணும். ரெண்டாவது வந்து நீங்க அவங்ககிட்ட வந்து என்னன்னா இறப்பை ஏற்படுத்துவதாகவோ இல்ல காயத்தை ஏற்படுத்துவதாக சொல்லி பயமுறுத்தி அந்த விருப்பத்தை அல்லது வந்து என்ன சொல்ல அவங்க சம்மதத்தை நீங்க பெற்றிருக்கணும். அப்படிங்கிற பட்சத்துல வந்து அது ரேப்பா கருதப்படும். ரெண்டாவது வந்து சில நேரங்கள்ல வந்து என்னன்னா உங்களுடைய சம்மதம் அப்படிங்கிறது வந்து நீங்க தவறான புரிதல் கூட நீங்க கொடுக்கப்பட்டிருக்கலாம். அண்டர் த இன்ஃப்ளூயன்ஸ் ஆஃப் மிஸ் அண்டர்ஸ்டாண்டிங், இது என்னோட கணவர் தான் அப்படிங்கிற மாதிரி, அது என்ன தெரியல, அந்த அடிப்பில் வந்து பாத்தீங்கன்னா அது ரேப்பா கருதப்படலாம். அடுத்தாப்புல வந்து பாத்தீங்கன்னா நீங்க வந்து ஏதாவது ஐ மீன் when you are under the influence of என்ன சொல்றது நமக்கு வந்து மனநலம் சரியில்லாத சமயத்திலேயோ அல்லது நம்ம வந்து மது அதனுடைய தூண்டுதல்ல இருக்கும் பொழுதோ அல்லது வந்து மற்ற கஞ்சாவோ அந்த மாதிரி வரக்கூடிய மற்ற பொருட்கள் இருக்கும் பொழுது எது நம்ம சம்மதம் கொடுக்கக்கூடிய அந்த பகுப்பு சிந்தனை இருக்கக்கூடிய பகுப்பாய்வு ரேஷனாலிட்டி அதை பாதிக்கக்கூடிய விஷயங்கள் கன்சென்ட் கொடுக்கக்கூடிய அத்தனை விஷயங்கள் எது பாதிக்குதோ அந்த மாதிரி இன்ஃபுளுன்ஸ் இருந்து நம்ம சம்மதம் கொடுத்துருந்தா அது வந்து சம்மதமா கருதப்படாது. பட் அது வந்து சொன்னா இட்ஸ் நாட் கன்சென்ட் அட் ஆல். அதை பின்னாடி நம்ம பார்க்க போறோம். that will be treated as rape. And லாஸ்ட் வந்து with the women under the age of 16 years. ஸோ அந்த 16 வயதுக்கு கீழே இருக்கக்கூடிய உங்களுடைய கன்சர்ன் நம்ம வந்து வேணா அது கன்சர்னாவே கருதப்படாது. நம்ம திரும்ப அந்த எக்ஸப்ஷனுக்குள்ள தான் நம்ம போக வேண்டியது. செக்ஷன் 369 சாரி இது வந்து பாத்தீங்கன்னா ரெண்டு விதமான இந்த ரேப்பை பொறுத்தவரை ரெண்டு விதமானதை நம்ம பாக்குறோம். ஒண்ணு வந்து பாத்தீங்க அப்படின்னா ஃபர்ஸ்ட் பார்ட் செக்ஷன் 375 போய் பார்த்தோம்னா அதுல வந்து ரேப்னா என்ன என் ஜெண்டர் அது வந்து கொடுக்கப்பட்டிருக்கு. ரெண்டாவது வந்து பாத்தீங்க அப்படின்னா ஒரு கஸ்டோடியல் ரேப் என்னென்ன அதுக்கான சர்க்கம்ஸ்டான்சஸ் அல்லது சில இன்ஸ்டன்சஸ் வந்து விளக்கியிருப்பாங்க. அது செகண்ட் பார்ட். அதை நம்ம சொல்லக்கூடிய 376A to D வரக்கூடியதெல்லாம் பாத்தீங்கன்னா கஸ்டோடியல் ரேப். அதாவது ஒருத்தருடைய வசத்தின் கீழே இருக்கும் பொழுது அதாவது சட்டத்திற்கு உட்பட்ட அவருடைய கட்டுப்பாட்டுல இருக்கும் பொழுது நடக்கக்கூடிய இந்த பாலியல் வல்லுறவுகளுக்கு வந்து பாத்தீங்கன்னா நம்ம வந்து இதை பார்க்கிறோம். இதுதான் வந்து செகண்ட் பார்ட் ஆஃப் திஸ் செக்ஷன் பர்டிகுலர்லி. இது என்ன பியூட்டி அப்படின்னு சொல்லி சொன்னா இதுவே அமெண்ட்மெண்ட்டுக்கே வந்ததான். நீங்க தொடக்க காலத்துல வந்து பாத்தீங்கன்னா சொல்ல பாத்தீங்கன்னா துகாராம் ஜட்ஜ்மெண்ட் நீங்க பொறுத்தவரை பாத்தீங்கன்னா பனிஷ்மெண்ட்டுக்கு ரொம்ப லோவா இருக்கும். ஆனா இதுக்கு அப்புறம் வந்து பாத்தீங்கன்னா மினிமம் பனிஷ்மெண்ட் 376 கீழே வந்து 7 years பனிஷ்மெண்ட் வந்து கொடுக்கப்பட்டிருக்கு. மினிமம் சென்டென்ஸ் ஆஃப் 17 years. இதுல வந்து பர்டிகுலரா அந்த கேஸ்க்கு அப்புறம் தான். ஆனா அந்த கேஸை பத்தி சொல்றதா இருந்தா என்னன்னா அந்த துகாராம பொறுத்தவரைன்னா மதுரான்னு ஒரு பொண்ணு இருக்கும். அந்த பொண்ணு வந்து ஒரு பையன் அசோக்குங்கிற ஒரு பையனை வந்து லவ் பண்ணும். அவனும் அவங்க அண்ணன் வந்து பாத்தீங்கன்னா அவங்க பேரண்ட் இல்லாம அவங்க வந்து இன்னொரு இடத்துக்கு வேலைக்கு போவாங்க. வேலைக்கு போய் அவங்க வந்து கூலி வேலைக்கு தான் போயிட்டு இருப்பாங்க. அவங்க ரெண்டு பேரும் வந்து லவ் பண்ணிக்கிட்டு இருக்காங்க. இந்த விஷயம் தெரிஞ்ச உடனே அவங்க அண்ணன் வந்து என்ன பண்றான் போய் வந்து கம்ப்ளைண்ட் கொடுக்கறதுக்கு போறான். இதை வந்து என்ன அந்த பொண்ணு வந்து இன்னொரு பையன் வந்து விரும்பிக்கிறோம். அவங்க அண்ணன் போய் புகார் கொடுத்துடுறாரு. அந்த புகார் கொடுத்ததுக்கு அப்புறம் வந்து பாத்தீங்கன்னா 2 பேரை வர சொல்றாங்க. அந்த பொண்ணு மதுராவும் அந்த அசோக்குங்கிற பையனும் வந்து வர்றாங்க. வந்த உடனே அவங்க 2 பேரை கூப்பிட்டு வந்து விசாரிக்கிறாங்க. விசாரிச்சுட்டு இருக்கும்போது பாத்தீங்கன்னா கூட வந்து அந்த பையன் இருப்பாங்க, கூட அவங்க பிரதர் இருப்பாங்க. இந்த 2 பேரையும் வெளியேற்றி விட்டுட்டு இந்த துகாராம் அப்படிங்கிற ஒரு போலீஸ் கான்ஸ்டபிள் அவர் என்ன பண்றாரு அப்படின்னா அந்த பொண்ணை வந்து அப்படியே டாய்லெட்டுக்குள்ள கூட்டு போறாரு. கூட்டு போய் அவங்கள வந்து பாலியல் வல்லுறவுக்கு உட்படுத்துறாரு எகெயின்ஸ்ட் அவங்களுடைய சம்மதத்தை மீறி. கொஞ்ச நேரம் கழிச்சு பாத்தீங்கன்னா அந்த பிரதர்ஸ் அந்த பையங்க 2 பேர் என்ன பண்றாங்க என்னடா ஒண்ணு வெளிச்சத்தை காணுமேன்னு சொல்லிட்டு சந்தேகத்தின் பேர்ல வந்து உள்ள போய் பாக்குறாங்க. அப்ப வந்து என்ன சொல்றான் அந்த போலீஸ் வெளியே வந்து என்ன சொல்றான் துகரம்ங்கிறவன் அந்த வெளியே வரதுக்கு முன்னாடி நடக்குன்னா இன்னொரு போலீஸ் போவாங்க. அந்த போலீஸ் வந்து பாத்தீங்கன்னா அவர் இன்டாக்சிகேஷன்ல இருப்பார், பயங்கர இன்டாக்சிகேஷன் இருப்பார். அந்த போதையில இருக்கிறனால வந்து அவரால் அந்த வல்லுறவு செய்ய முடியாது. சும்மா ஹாரஸ்மெண்ட் மட்டும் செக்ஷுவல் ஹாரஸ்மெண்ட் பண்ணிட்டு அவர் வருவார். வரும்போது வந்து பாத்தீங்கன்னா கேட்பாங்க அந்த இருட்டா இருக்கு என்ன ஆச்சு அப்படின்னு சொல்லி அந்த மதுரா பத்தி கேட்கும் பொழுது அவ அப்பவே போயிட்டா நீங்க கிளம்புங்க அப்படி மாதிரி சொல்லும் போது அந்த பொண்ணு வெளியே வரும். வெளியே வந்தோம் என்ன சொல்லுவோம் இந்த மாதிரி வந்து என்ன இப்படி பண்ணிட்டாங்க அப்படின்னு சொல்லி சொல்லுவோம். இதான் அதோட பேக்ரவுண்ட் தான் கேஸ். கீழே இருக்க பொறுத்தவரை வந்து பனிஷ்மெண்ட் கொடுக்குறாங்க. அது வந்து சுப்ரீம் கோர்ட்டுக்கு போகும். போற சமயத்துல வந்து பாத்தீங்க அப்படின்னு சொல்லி கீழே இருக்கக்கூடிய பனிஷ்மெண்ட் வந்து பாத்தீங்கன்னா ரொம்ப கம்மியா இருக்கும். ஜஸ்ட் 3 years ஆஃப் ரெகுலர் இம்ப்ரெஸ்மெண்ட். அந்த ரெண்டாவது போன போலீஸ்க்கு வந்து பாத்தீங்கன்னா 1 years ஆஃப் ரெகுலர் இம்ப்ரெஸ்மெண்ட் சம்திங் கொடுக்கப்பட்டிருக்கும். ஆனா மேல போகும்போது என்ன தேவர் அக்யூட்டட் பேஸ்ட் ஆன் சம் எவிடன்சஸ். இந்த மாதிரி வந்து என்ன சொல்றது இதை ரிகரஸா ஃபாலோ பண்ண சமயத்துல போகுது. இது வந்து நாடு முழுவதும் ஒரு கொந்தளிப்பை ஏற்படுத்துது. அதுலதான் சில சேஞ்சஸ் வந்து அவங்க கொண்டு வர்றாங்க. ஸோ இதுக்கு அப்புறம் தான் வந்து பாத்தீங்கன்னா மினிமம் பனிஷ்மெண்ட் வந்து பாத்தீங்கன்னா 7 years ஆஃப் பனிஷ்மெண்ட் அண்டர் செக்ஷன் 376 ஆஃப் ஐபிசில பிரிஸ்கிரைப் பண்ணப்படுது. கிளாஸ் 2 பொறுத்தவரை வந்து சொன்ன மாதிரி என்ன சொல்றது சம் சர்க்கம்ஸ்டன்சஸ் ஆர் எக்ஸ்பிளைன்ட் வேரின் கஸ்டோடியல் ரேப் இஸ் கமிட்டட். ஃபர்ஸ்ட் வந்து பாத்தீங்க அப்படின்னா போலீஸ் ஆபீசர் வந்து அவருடைய கஸ்டடியில இருக்கும் பொழுது அந்த பாலியல் வல்லுறவை அந்த குற்றத்தை செஞ்சா அல்லது அவருக்கு கீழே இருக்கக்கூடிய ஒரு அதிகாரியின் கீழே அவருக்கு உட்பட்ட சபார்டினேட்டிவ் அவருக்கு கீழே இருக்கக்கூடிய அதிகாரியுடைய கஸ்டடியில அவருடைய கட்டுப்பாடுல இருக்கக்கூடிய ஒரு பெண் மேல வந்து பாலியல் வலுவல் ஏற்படுத்தப்பட்ட இந்த வந்து அஃபென்ஸாக கருதப்படும். ரெண்டாவது வந்து பாத்தீங்க அப்படின்னா பப்ளிக் சர்வெண்ட். பப்ளிக் சர்வெண்ட் வந்து தன்னுடைய அதிகாரத்தை தவறாக துஷ்பிரயோகம் பண்ணும்போது டேக்கிங் அட்வான்டேஜ் ஆஃப் இஸ் அபிஷியல் பொசிஷன் அப்படிங்கிற பட்சத்துல வந்து இந்த மாதிரி பாலியல் வலுவல் ஏற்படுத்தினா அது வந்து 375 இன்வோக் பண்ண முடியும். மூணாவது வந்து பாத்தீங்கன்னா கமிட்டட் ஆன் தி இன்மேட் ஆஃப் எனி ஜெயில். அப்ப எனி ஜெயில் அப்ப வந்து பாத்தீங்கன்னா ரிமாண்ட் ஹோம்ல வந்து நடக்கக்கூடிய இந்த பாலியல் வலுவல்கள் எல்லாமே வந்து பாத்தீங்கன்னா இது வந்து 375 கீழே வரக்கூடியது. நாலாவது வந்து பாத்தீங்கன்னா இந்த ஹாஸ்பிட்டல். ஸோ இந்த ஹாஸ்பிட்டல் வந்து பாத்தீங்கன்னா ஐதர் பை த மேனேஜ்மெண்ட் ஆர் ஸ்டாஃப் ஆஃப் தி ஹாஸ்பிட்டல் அவங்களால வந்து இந்த விக்டிமோட பாதிக்கப்பட்ட அந்த பெண்ணோட விருப்பத்திற்கு மீறி நடக்கக்கூடிய விஷயங்களுக்கெல்லாம் வந்து இது வந்து பொருந்தும். அடுத்து வந்து பாத்தீங்கன்னா எகெயின்ஸ்ட் பிரெக்னன்ட் உமன், கர்ப்பிணி பெண்களுக்கு அவங்களுக்கு எதிராக நடக்கக்கூடிய இந்த பாலியல் வல்லுறவு குற்றங்கள். ரெண்டாவது அடுத்து வந்து பாத்தீங்கன்னா 12 வயதுக்கு கீழே இருக்கக்கூடிய சிறுமிகள் மீது பண்ணக்கூடிய ஏற்படுத்தப்படக்கூடிய பாலியல் குற்றங்கள் அப்படிங்கிற பாலியல் வல்லுறவு குற்றங்கள். அடுத்து வந்து பாத்தீங்கன்னா கேங் ரேப், கூட்டு பாலியல் பலாத்காரம் சொல்லக்கூடிய இந்த எல்லாமே வந்து பாத்தீங்க அப்படின்னா கஸ்டடி கீழே ஒருத்தருடைய கட்டுப்பாட்டின் கீழே இருக்கும் பொழுது இது எல்லாமே ரேப்பா வந்து நம்ம சொல்றோம். இது வந்து செகண்ட் பார்ட் ஆஃப் செகண்ட் கிளாஸ் ஆஃப் செக்ஷன் 375 அப்படின்னு பார்க்கணும். இங்க என்ன வந்து ரொம்ப எசன்ஸ் ரியலி தி கிராக்ஸ் ஆர் சொல்றது லைஃப் ஆஃப் தி திஸ் என்ன சொல்ற செக்ஷன் இஸ்ங்கிறது வந்து கன்சென்ட் தான். இந்த கன்சென்ட் இருந்துச்சுன்னு சொன்னா அதை வந்து அவங்களை காப்பாற்றும் அப்படின்னா அது கிடையாது அப்படிங்கிறத செக்ஷன் 375 பார்க்கணும். நம்ம வந்து திரும்பவும் என்ன சொல்றது we have to this section must be subjected to exception under chapter 4 of IPC. அது என்ன சொல்ற செக்ஷன் 90 பர்టిక్యులர் கன்சென்ட் பத்தி வரும். கன்சென்ட் எங்க இருக்கு? கன்சென்ட் யாரால கொடுக்க போறது? அண்டர் ஃபியர் ஆர் மிஸ்கன்செப்ஷன் கொடுத்திருந்தா நீங்க கான்ட்ராக்ட் ஆக்ட்ல கூட படிக்கலாம், அது கன்சென்ட்டா கருதப்பட முடியாது. ஆனா இட்ஸ் a question of fact. நான் வந்து ஃபியர்ல கொடுத்தேன் அல்லது மிஸ்கன்செப்ஷன்ல கொடுத்தேன் அப்படிங்கிறது கொஸ்டின் ஆஃப் ஃபேக்ட். அது யாரு கிளைம் பண்றாங்களோ அவங்க தான் ப்ரூவ் பண்ணணும். பட் ஆனா தட் கேன் பி கன்சர்ன் இந்த தட் கேன் பி ட்ரீட்டட் as a concern. அதுங்கிறது வந்து கன்சர்ன் given under fear or misconception. ரெண்டாவது கன்செப்ஷன் ஆஃப் ஃபேக்ட் அந்த மிஸ்டேக் ஆஃப் ஃபேக்ட் மிஸ்டேக் ஆஃப் லாவோட போய்க்கும். அடுத்து வந்து பாத்தீங்கன்னா கன்சென்ட் ஆஃப் இன்சைன் பர்சன் ஆர் அண்டர் இன்டாக்சிகேஷன். ஒருத்தர் வந்து அந்த மாதிரி போதையில மதுவில் இருக்கும் பொழுதோ அல்ல மற்ற பொருட்கள்னால வசதினால வந்து தூண்டுதல் அதோட இன்ஃபுளுன்ஸ் இருந்தாங்க அப்படின்னு சொன்னா கன்சென்ட்டா கருதப்படாது. இன்சைன் பர்சன் ஆட்டோமேட்டிக்கா போயிடும். அடுத்து கன்சென்ட் ஆஃப் அ சைல்ட் தட் கேன் பி ட்ரீட்டட் as a consent given by a child. அடுத்து வந்து பாத்தீங்கன்னா கன்சென்ட் obtained under fear of death or hurt. நான் எப்படி சொல்ற மாதிரி நீங்க பயமுறுத்தி அல்லது சாவை உண்டாக்குகிற பயமுறுத்தி நீங்க வந்து பண்ண ஒரு கன்சென்ட் பெற்றிருந்தா தட் கேன் பி ட்ரீட்டட் as a consent. அடுத்து வந்து பாத்தீங்கன்னா மேரேஜ் பண்ணிக்கிறேன் அப்படின்னு சொல்லி நீங்க வந்து கொடுக்கக்கூடிய வந்து பாத்தீங்க அப்படின்னா அது வந்து கன்சென்ட் கிடையாது. ஒன் மினிட், ஐம் சாரி. அடுத்த லாஸ்ட் வந்து பாத்தீங்கன்னா கன்சென்ட் ஆஃப் உமன் அண்டர் 16 years of age. இது எல்லாமே வந்து பாத்தீங்க அப்படின்னா கன்சென்ட்டா கருதப்பட முடியாது. தீஸ் ஆர் எக்ஸெப்ஷன். இதை பேஸ் பண்ணி தான் நீங்க என்ன செஞ்சிருப்பீங்க அப்படின்னா 114 ஆஃப் ஏ ஆஃப் இந்தியன் எவிடன்ஸ் ஆக்ட் வந்து பாத்தீங்கன்னா வித் ரிகார்ட் டு ரேப் அப்படின்னு அதுல என்ன சொல்லப்பட்டிருக்கும் அப்படின்னா ஒரு லேடி வந்து அவங்களோட ப்ரொஃபஷனை வந்து பாத்தீங்க அப்படின்னா அவங்க இந்த மாதிரி ப்ரொஃபஷன் ஈடுபட்டுக்கிட்டு இருக்காங்க அப்படிங்கிறதுக்காக அவங்க கன்சென்ட், அதாவது உமன் ஆஃப் ஈஸி வர்ச்சுன்னு அழைக்கப்படுவாங்க. உமன் ஆஃப் ஈஸி வர்ச்சு அவங்க எல்லாமே வந்து பாத்தீங்க அப்படின்னா அவங்க அந்த மாதிரி குற்றங்களை ஈடுபடுறாங்க, அதனால அவங்க வந்து கன்சென்ட் கிடைச்சிச்சு அப்படின்னு சொல்லி ஈஸியா கட்டிட முடியாது. அண்ட் ஒன்ஸ் இட் இஸ் கமிட்டட் அப்படின்னு சொல்லி சொன்னா the court is empowered to presume that it is done without the consent அப்படிங்கிறத 114 நம்ம வந்து பார்க்கலாம் அந்த அமெண்ட்மெண்ட்டை பொறுத்த வரையில. ரெண்டாவது வந்து பாத்தீங்கன்னா நிறைய வந்து இப்ப now it is pending before the honorable apex court with regard to marital rape. So the rape which is committed by the very husband against his own wife, அதுமே வந்து ஸ்டில் இட் இஸ் அண்டர் கொஸ்டின். அது வந்து என்ன சொல்றது, அதுமே ட்ரபிள் போயிட்டு தான் இருக்குது. பிகாஸ் நம்மளுடைய பொறுத்தவரை நம்ம கல்ச்சரை பொறுத்தவரையில வந்து we don't treat it. அதனால வந்து என்ன பட் ஸ்டில் இட் இஸ் என்ன சொல்றது அண்டர் கொஸ்டின் அண்ட் இட் இஸ் பெண்டிங் பிஃபோர் தி ஆனரபிள் அபெக்ஸ் கோர்ட். அடுத்து வந்து பார்த்தா செக்ஷன் 376 வந்து பனிஷ்மெண்ட் ஃபார் ரேப். இது இன்னொன்று விஷயம் என்னன்னா செக்ஷன் 220A வந்து பாத்தீங்கன்னா இன்ட்ரோடியூஸ்டு இது. அது என்ன அப்படின்னா பர்டிகுலர் சொல்லக்கூடியது வந்துன்னா டிஸ்க்ளோஷர் ஆஃப் ஐடென்டிட்டி ஆஃப் த விக்டிம் பை தி certain offenses. So இந்த மாதிரி வரக்கூடிய 354A to D, 376A to D இதுல வரக்கூடிய அஃபென்சஸ் எல்லாத்தையும் நீங்க பாத்தீங்க அப்படின்னா இதுல பாதிக்கப்பட்ட அந்த குழந்தைங்களோ அந்த பெண்களோட ஐடென்டிட்டியை வந்து நம்ம பிரிண்டோ பப்ளிஷ்கோ நம்ம கொடுக்க கூடாது அப்படிங்கிறதா செக்ஷன் 220A ஆஃப் ஐபிசி. தட் இஸ் ஆல்சோ இன்ட்ரோடியூஸ்ட் ஆஃப்டர் திஸ். அதனுடைய அக்கம்பனிட் பை திஸ் செக்ஷன் வந்து பாத்தீங்கன்னா இதுவே இட் வாஸ் இன்ட்ரோடியூஸ்ட் டு ஐபிசி அப்படின்னு பார்க்கணும். அதுல வந்து பாத்தீங்கன்னா பர்டிகுலரா வந்து ஆனரபிள் சுப்ரீம் கோர்ட் வந்து லேட் சம் கைட்லைன்ஸ். எதுல அப்படின்னு சொன்னா ஏறக்குறைய ஒரு 8 கைட்லைன்ஸ் வந்து கொடுத்திருப்பாங்க. எதுக்காக அப்படின்னு சொன்னா ஃபார் அசிஸ்டன்ஸ் ஆஃப் விக்டிம்ஸ் ஆஃப் ரேப். இந்த பாலியல் பலாத்காரத்துக்கு உட்பட்ட அந்த பெண்களுக்கு அல்லது சிறுமிகளுக்கு வந்து பாத்தீங்கன்னா அது என்ன சொல்றது அவங்களுக்கான உதவிகள் செய்யறதுக்கு ஒரு 8 கைட்லைன்ஸ் கொடுக்கப்பட்டது. அதே மாதிரி தேசிய பெண்கள் பாதுகாப்பு ஆணையத்திற்கும் அந்த ரெக்கமெண்டேஷன்ஸ் போயிருக்கும். பட் தட் வாஸ் நாட் அன்பார்ச்சுனேட், தட் வாஸ் நாட் ஆல்சோ டிரான்ஸ்லேட்டட் டு ஆக்ஷன். அது வந்து வரல. பட் அதுல சில விஷயங்கள் கொடுத்துருப்பாங்க. என்னன்னா அவங்களுக்கு ஒரு லீகல் ரெப்ரஸன்டேஷன் கொடுக்கலாம். ரெண்டாவது வந்து பாத்தீங்கன்னா அவங்களை என்கொயரி பண்ண சமயத்துல வந்து பாத்தீங்கன்னா அந்த பாதிக்கப்பட்ட பெண்களுக்கு வந்து சட்டப்படியான பிரதிநிதித்துவம், அதாவது அவங்களோட ரெப்ரஸன்டேஷனுக்காக வந்து ஸ்பேஸ் கண்டிப்பா கொடுக்கணும். ரெண்டாவது வந்து பாத்தீங்கன்னா லிஸ்ட் ஆஃப் அட்வொகேட்ஸ் நீங்க வந்து ப்ரிப்பேர் பண்ணல. யாராரு இந்த மாதிரி வழக்குகள்ல அவங்க வந்து முன்னிலையாக விரும்புறாங்க அப்படிங்கறதையும் அவங்க வந்து தங்களோட பேரை வந்து பதிவு செஞ்சுக்கலாம் அப்படிங்கறது. ரெண்டாவது வந்து பாத்தீங்கன்னா மிக முக்கியமானது, தட்ஸ் வாட் ஆல்சோ வி தி மேஜிஸ்ட்ரேட்ஸ் ஆர் அண்ட் எவ்ரி ஜட்ஜ் இந்த மாதிரி கேசஸ் டீல் பண்ணக்கூடிய ஆனரபிள் ஜட்ஜஸ் அவங்க ஆல்மே சொன்னா தேர் ஒப்ளைஸ்ட் என்னன்னா அனானிமிட்டி ஆஃப் தி விக்டிம்ஸ் போத் இன்வெஸ்டிகேட்டிங் ஆஃபீஸர். இப்போ நான் 164ல வந்து ரெக்கார்டிங் ஆஃப் த ஸ்டேட்மெண்ட் அந்த 164A வந்து விக்டிமோட இது வந்து 64ல வந்து விக்டிமோட ஸ்டேட்மெண்ட் ரெக்கார்ட் பண்ணும்போது பாத்தீங்கன்னா அந்த அனானிமிட்டி ஹாஸ் டு பி மெயின்டைன். அவங்க வெளிப்படுத்தக்கூடாது. ஈவன் தி ஜட்மெண்ட் ஆல்சோ. ஏன்னா அது நம்மளுடைய கல்ச்சரை பொறுத்தல அவங்களுடைய வாழ்க்கையை ஃபியூச்சரை கம்ப்ளீட்டா பாதிக்கும் அப்படிங்கிற அடிப்படையில அதுதான் என்ன சொல்ல அனானிமிட்டி ஹாஸ் டு பி மெயின்டைன். அதை நம்ம வெளிப்படுத்த கூடாது. அப்புறம் வந்து பாத்தீங்கன்னா காம்பன்சேஷன் போர்டு அண்டர் ஆர்டிகல் 338(1) ஆஃப் கான்ஸ்டிடியூஷன் அடிப்படையில வந்து ஒரு காம்பன்சேஷன் போர்டு வந்து உருவாக்கி இதுக்காக சில விஷயங்களை வழிவகுக்கலாம் அப்படிங்கிறது சொன்னாங்க. அடுத்து வந்து பாத்தீங்கன்னா நம்ம வந்து 357 கீழே வந்து காம்பன்சேஷன் ஃபார் விக்டிம்ஸ் இந்த மாதிரி இருக்கக்கூடிய பாலியல் பலாத்காரம் உட்பட்ட பாதிக்கப்பட்ட பெண்களுக்கு அல்லது சிறுமிகளுக்கு வந்து பாத்தீங்கன்னா அவங்களுக்கு இழப்பீடு கொடுப்பதற்கும் வழிவகுக்கப்பட்டது இந்த ஜட்ஜ்மெண்ட். அது என்னன்னு சொல்லிச்சுன்னா டெல்லி டொமஸ்டிக் ஒர்க்கிங் விமென்ஸ் ஃபோரம் வர்சஸ் யூனியன் ஆஃப் இந்தியா அண்ட் அதர்ஸ். இதுல வந்து பாத்தீங்க அப்படின்னா இந்த 8 கைட்லைன்ஸ் கொடுக்கப்பட்டது. ஸோ தீஸ் ஆர் தி திங்ஸ் இதுதான் உங்களுக்கு சொல்ல விரும்பினது. ஸோ நம்ம வந்து பார்த்து இன்னைக்கு என்ன அப்படின்னு சொன்னீங்கன்னா கிரிமினல் ஃபோர்ஸ் அசால்ட். அது இன்னொன்று சொல்ல வந்து கிரிமினல் ஃபோர்ஸ் அசால்ட்டை பொறுத்து வந்து பாத்தீங்கன்னா அந்த வேர்டிங்ஸ் மேபி மோர் ஆர் லெஸ் ஓவர்லாப்பா இருக்கும். அது ஒரே செக்ஷன்ல கொண்டு வரலாங்கிற வந்து ப்ரொபோசல் வைக்கப்பட்டது. அன்பார்ச்சுனேட்லி தட் வாஸ் ஆல்சோ நாட் டிரான்ஸ்லேட்டட் இன்டு ஆக்ஷன். அது வந்து கிரிமினல் ஃபோர்ஸ் அண்ட் அசால்ட்ங்கிறத வந்து பார்த்தோம். அடுத்து வந்து பாத்தீங்கன்னா ராங்ஃபுல் ரெஸ்ட்ரெயின்ட் அண்ட் ராங்ஃபுல் கன்ஃபைன்ட்ங்கிறத பார்த்தோம். அடுத்து வந்து பாத்தீங்கன்னா அந்த செக்ஷுவல் ஹாரஸ்மெண்ட் 354 அதில் வரக்கூடியது. தென் கிட்னாப்பிங் அண்ட் அப்டக்ஷன். லாஸ்ட்ல வந்து செக்ஷுவல் அஃபென்சஸ்ல பர்டிகுலர்லி செக்ஷன் 375, 376 அண்ட் செக்ஷன் 220A ஆஃப் ஐபிசி வந்து நம்ம வந்து பார்த்துக்கலாம். இந்த 220A பர்டிகுலர் வந்து பாத்தீங்கன்னா நாட் டு பப்ளிஷ் ஆர் print the identity of the victims of rape. That we have to maintain the anonymity of victims of rape. So class is over. Thank you so much.